You're welcome back. My name is Raymond Akwa. This is UPfront. Today, the U.S. Ambassador to Ghana, Robert Jackson, is stirring further controversy, declaring that, and if I can quote him, he is frankly disappointed with the public backlash that has greeted the U.S.-Ghana military cooperation agreement currently before Parliament. We are now also learning that at every one time, a total of 200 U.S. soldiers with heavy military equipment will operate from Ghana, staging and deploying forces from here, this country. The minority in Parliament has been left angered by the U.S. ambassador's pronouncement, describing them as insulting and regrettable. The opposition NDC has also been holding a press conference, if you've not been following the news recently, just earlier today, describing the situation as very terrible, something that if even this Parliament is unable to throw out, the new government that are coming in 2021 would actually deal with in a much more comprehensive manner. But we'll be hearing from all of this pretty soon. And the more important part is the gentleman I have in the studio as my guest now. The Honorable James Agaga is a member of Parliament. More importantly, he speaks on interior and defense for the minority. He's the former Deputy Interior Minister. Honorable, you're welcome.
Thank you, Raymond.
I hope you're doing well.
I'm fine by God's grace.
Yes, you seem to. And the latest development is that the U.S. ambassador, who is perhaps the representative for Donald Trump in Ghana, that's the U.S. government in Ghana today, is telling us that he's heavily disappointed that people like you are really worried about an agreement which he believes is giving us 20 million, will be to Ghana's interest, will prop up the kind of military we have in Ghana. And so we are clear. We already have 200 of these soldiers in the country. More will be coming after this agreement. So what's the big deal in this particular case?
Raymond, the least said about 20 million, the better. Is that the worth of Ghanaians? Is that the worth of the sovereign status of Ghanaians? 20
million every year.
20 million, yes. Is that our worth? So you sell the sovereignty of Ghana for 20 million a year?
But the sovereignty of Ghana is not for sale at any point in time in this agreement, is it?
Absolutely. The sovereignty of Ghana is not for sale. But if you go through the agreement which is before Parliament, and you go through painstakingly the articles, you would arrive at the conclusion that what the agreement seeks to do is to designate areas within the sovereign territory of Ghana for the exclusive use of the United States Armed Forces. Our laws will not have any form of application within those designated areas and facilities that the United States Armed Forces would have exclusive access and use of. When you do that within a sovereign state, you are selling your sovereignty.
The interesting part in all of this is that, Honorable, and I dare not interrupt you, but I want to be clear in my mind. You met with the defense minister. He told us in the press conference that he explained to you in that particular engagement that that is something that's going to happen today, not tomorrow, under the watch of Nana Danko Akufo-Addo. And that this is just an enhancement upon previous arrangements that your government, actually supervised in times past. And what he's doing is rather being open about that process.
I am scandalized that attempts are being made to create the impression that previously, whatever arrangements we may have struck with the United States government in relation to our military cooperation is the same agreement which has now been brought back before Parliament for consideration. If that were the case, why bring back a brand new agreement for Parliament's consideration? We should have continued with the old agreements.
Okay.
But it is even clear, if you go through the articles of this new agreement, that what they are seeking is an enhanced form of military cooperation, which will take the form of granting them unimpeded access to military facilities, which qualifies for bases. And I've heard people argue strenuously that they are not going to set up military bases in the country. The fundamental question to ask is, what is a military base? I mean, if you are granting access and unimpeded access to facilities, you know, that belong to our military, to a dominant military power, the United States of America.
You
turn around, you look at us in the face and say, they are not going to create a military base in this country. They won't have permanent military presence. They are bringing in equipment, heavy machinery. They are entitled to bring into this country material, which has not even been defined. I mean, in Article 7, I'll take you through Article 7.
Okay, I'll come back
it
to
could
that.
Even, those material could even pass for chemical weapons, nuclear weapons.
No,
they are entitled to bring those into
that
our
you
country.
are clarifying and seeking to ask these questions in the open. When the defense minister was before you just yesterday, so what kind of deliberation did you have with him? Why has all of these questions not been clarified? Because he insists that, one, there's no base at play here. Two, he says there are two facilities around the Kotoka International Airport. These are the facilities that they will be using. He also proceeds to say that, of course, after training, they'll surely engage us in training, which
His explanation was simply not satisfactory. It was simply not satisfactory because he tried to create the impression that all along we've had similar agreements in place with the United States government.
Haven't we?
We have perused those agreements, and I can tell you
which years on are you talking
that
about?
we have never come close to having a deal which would grant the United States government unimpeded access to military facilities, and that once they have access to those facilities, Ghanaians, our own military personnel, cannot even enter those facilities for inspection. In some cases, we've never come close to having such a deal
just like
with the United States.
Forgive me, but you conveniently leave out the part where these are agreed facilities. It's not as if they put a gun to our head to agree to the specific facilities that we ought to agree to.
That is why we are of the view that the agreement does not serve the interest of Ghana. It serves the interest of the United States of America.
Have you been told these agreed facilities?
Yes, we have.
You've been told as Parliament?
Absolutely.
Which ones are we
talking about? But there is room for expansion if you go through the text of the agreement.
Sorry, I want to be clear. Which ones are we talking about?
We're talking about the airport, facilities dotted around the airport, the runway. We are saying that as a sovereign country...
Are these the only facilities they have unimpeded access to?
If you look at the agreement, there is room for further agreements to be made subsequent to the coming into force of this particular agreement, if we were to allow it to pass.
And they say as mutually agreed.
Absolutely.
So Ghana has to really agree before any other facility is used.
All over the world, wherever the United States has established military bases, there was initial mutual consent and agreement.
Yeah.
But after the initial consent, you are also aware about the numerous human rights abuses that have been occasioned as a result of the presence of those military facilities, I mean, in those host countries. Talk about the threat to our own security, the fact that, you know, we become legitimate targets to the adversaries of the United States. Can you quantify that in monetary terms, by the way? So when Ambassador Jackson says they're going to pay 20 million Ghana cedis or invest 20 million in training, etc., and so that is our worth, I mean, it's regrettable.
Just regrettable?
Absolutely, and unfortunate.
But he represents the US of A.
Of course, so that is why we think that this agreement is not at arm's length and should be rejected outright by the Nana Addo government. It doesn't serve the best interest of Ghanaians, which is why we're saying that we shouldn't have this agreement in the first place. Now, it's not born out of ill motive. We've had bilateral ties with the US since independence. But we're saying that this particular agreement will not serve our best interest. It undermines our sovereignty. It would undermine our security in the long term.
And I've seen you elucidate the point on unimpeded access. Is that the only problem you have with this particular agreement?
There are numerous provisions in the agreement.
Okay, so you start with chapter 5.1, which is the unimpeded access part.
Yes, you can. Let me take you to Article... Is that Article 11?
Okay. Article 11 actually deals
with...
Article...
let me start with Article 7. Pre-positioning and storage of equipment, supplies, and material.
Yeah, what's the problem with that?
Yes.
It says that they are hereby authorized to pre-position and store defense equipment supplied and the materials as agreed facilities and areas. The pre-positioned material of the United States forces and the agreed facilities and the areas of portions thereof designated for storage of such pre-positioned material shall be for the exclusive use of the U.S. What is really the problem here?
The point is that if you look at the article, it doesn't even define what material they can bring into our country. I made that point earlier that if they were to bring in chemical weapons,
yes,
right?
And the minister did not clarify that when he met you.
I mean, how can he? There is an interpretation section in the agreement, so it is not what the minister says, which is authoritative.
But
the ministers will come and go, but this agreement has some. Of course, it would outlive governments.
Yes,
you see, and so whatever the minister says now would not supersede or override what has been expressly captured in the agreement. Material has not been defined in the interpretation section.
But
and I'm saying that
I want to be clear.
Yes.
Did the minister clarify that to you at your committee level?
We asked. In fact, when we got to this particular point, we called for the entire article to be expunged.
Okay.
Because it doesn't serve our best interest. Okay. So that is one
And what
point.
was the response? The other side said it's okay.
Well, we made our point.
Okay.
The minority must have its say. But we're saying that you don't use numbers to achieve certain goals that in the final analysis would not be to the interest of the state.
Okay.
That is the point.
So
let me take you to Article 15.
Okay, so 15 talks about claims.
Article 18.
Okay, 15 first. What's the problem with the claims? It says, other than contractual claims, the parties waive any and all claims against each other for damage to or loss or destruction of property owned by the party or death or injury to any military personnel and civilian employees of either party arising out of the performance of their official duties in Ghana. What's the problem with that?
The problem is that you're simply saying that third parties have no right to make claims, right?
And third parties in this case will be who and which grouping?
You could pass for a third party. You could pass for a third party.
I see.
So if U.S. military personnel or contractors cause injury to your person, you'll not be entitled to make claims for damages in the court of law. That is what this means.
But can anybody?
They're saying that even in the event that
anybody contract away my rights that way?
Well, but that is what this article seeks to do, which is why we think there is everything wrong with the agreement.
Okay.
Yeah, there are provisions which also seeks to oust entirely the jurisdiction of our courts. Look at Article 18, settlement of disputes.
Very much so. It says all of this will be done, shall be for, in fact, it said the resolution will be between the two agents for consideration and resolution, as in the ministers of defense for the two countries, right?
This is an ouster clause. And that is why we believe strongly that if this agreement passes, it will undermine the sovereignty of Ghana. You cannot come into our country because Ghana is going to be the designation for the implementation of this agreement. You're saying that our courts should be bereft of jurisdiction in the event of disputes arising in relation to this agreement. I mean, it's a subjugation of our laws, I mean, in favor of United States laws. But we are a sovereign nation. I mean, there's supposed to be equality between states, I mean, in line with Westphalian principles.
How is there subjugation when indeed what it says here is that, I mean, all the parties in terms of, it shall be referred to the parties for consultation and resolution as appropriate. It shall not be referred to any other national, international court, tribunal, similar, or third party for settlement unless otherwise mutually agreed on.
Mutually agreed, so they can at will say, no, if you have to go to court, you must seek our consent. If it's not in their interest to go to court because they think they have offended or done wrong, they would simply withhold consent. Which is why we think that our very sovereignty is at stake here. If such an agreement with such a provision, an article, is allowed to pass.
It's interesting. When we return from this break, which I'll be back on pretty soon, we'll get to know what's the difference between the current agreement and the 1998 one, the 2015 one, and others that have been signed in times past. We'll also get to know exactly what you intend doing after this. But we cannot go for a short break. You're welcome back. This is Upfront. Is the latest development on the controversial cooperation and defense level agreement between Ghana and the US of A. That's the crux of our conversation today. My guest is the minority spokesperson on defense and interior, the Honorable James Agaga. He's in the studios here. Earlier, the NDC did a press conference. Earlier, the U.S. ambassador also spoke, making the developments in the country today pretty much interesting about which direction to go. But already, he said it's very disappointing and unfortunate that, of course, no, the U.S. ambassador said was disappointed. You're also saying that it's unfortunate that the ambassador seems to be worried that we are talking about this deal the way we are talking about it. And he says that it's in our interest, 20 million is not a small money. He actually states you disagree with that. But we're going article by article what your problem with this particular deal is, and we ended off with 18. Is there another one that you want to bring to our attention before we jump into the other level of our conversation?
I would like to quickly draw your attention to Article 2.
Okay, that's the purpose and the scope of this agreement.
And the scope of this agreement. I mean, this particular article.
Which of these
Article 2
clauses are you dealing with now?
Let's deal with one. It says, this agreement sets forth a framework for enhanced partnership and security cooperation between the parties. Now, the point is, this particular article sets this agreement apart from all previous agreements we have had with the United States government in relation to military cooperation.
Sorry, why do you think so?
Yes. And that takes us back to Article 5.
This was just a framework.
Yes.
For enhanced partnership.
Yes. So clearly it means that this particular agreement would enhance whatever cooperation existed previously. That is the point. So if anybody comes to tell you...
It could just be coinage too, really.
Well, no, but I will demonstrate that, yes, in reality, there are differences.
Okay, show us now.
In Article 5.
We spoke about
access.
Article 5,
We've spoken about Article 5, but that article grants unimpeded access and use of agreed facilities and areas.
Are you saying that...
Including our airport.
The 2015 agreement never had this?
No. I'm saying that on authority. The 2015, and a lot has been said about 2015 agreement. That was just, I mean, a logistic support agreement between Ghana and the US. Nowhere in that agreement is it stated that the United States of America shall have unimpeded access and exclusive use of areas and facilities, you know, that belongs to our military.
What's the coinage in that particular article about access to and use of facilities?
There is none. This is a logistics support agreement.
Yes.
And the wording is self-explanatory.
I get your point.
Yes.
You are saying that there's no part in this agreement that there's also a section dealing with the access to and the use of agreed facilities and areas. Is that what you're
absolutely.
Saying? Not at all.
Absolutely.
How about the one in 1998?
If you go through the 2015 agreement, you'd also realize that there is respect for the laws of either country.
Where is that stipulated?
United States. Oh, I can take you through. I've gone through the agreement. Let me quickly take you through. Sorry. Yes, 3.
Okay, what does it say?
All activities of the parties under this agreement and any implementing arrangement shall be carried out in accordance with their respective national laws and regulations.
Okay, so contrary to the one that says that claims by a third party for damages or losses caused by military personnel and civilian personnel shall be resolved by the United States government in accordance with U.S. laws and regulations.
Absolutely. There is no sense of equality whatsoever espoused in the agreement that is currently before us. But in the previous arrangement, there was.
Is there a provision in the 2015 agreement on taxes?
No.
There isn't any?
No.
There isn't any that talks
about...
There
is a clause on
tax waivers.
Reimbursement, yes, reimbursement, etc. That's all. It's a very short agreement, but with many annexes.
Okay,
yes.
But let me be clear. So you are stating categorically that that particular agreement in 2015 is in no way like the current agreement?
Absolutely.
How about the one in 1998?
In 98?
Yes.
Yes, there were some similarities.
Yes.
But
major similarities.
Not major.
The similarities actually outweigh the differences?
I don't think so.
Really?
There are fundamental differences.
Like what specifically?
But the differences is actually what forms the crux of the views expressed by the overwhelming majority of Ghanaians and the minority in parliament.
Okay.
Article 5
of the 1998 one.
Yes.
What does it say?
That is the article which grants unimpeded access to facilities and areas for the exclusive use of the United States Armed Forces within the sovereign territory of Ghana. That provision does not find expression in the 1998
not
agreement
in any form at all
whatsoever.
Okay. How about the part to do with taxes?
Yes.
There is?
Yes, there is.
Okay. So what other controversial point has been raised now beyond the taxes in this case?
The jurisdiction of Ghana was, of our courts, was not compromised in the 1998 agreement, which came in the form of diplomatic notes anyway.
So what's your point?
There was no such provision. And so you can't talk about ouster clauses here, that the jurisdiction of Ghanaian courts would be ousted in the event of disputes arising out of the implementation of the agreement.
So it sounds to me like
there is no provision whatsoever in the 1998 agreement which allowed the United States government to bring material, equipment into this country without allowing our authorities to inspect safe. There is no such provision in the 1998 agreement. So there are fundamental differences.
So you mentioned 3, to be fair. These fundamental
I can continue. Do you want me to continue?
Yes, if there are more, so that we know that in reality they outweigh the kind of, because there are over 18 articles in the 20, what do you call it, this year's agreement
yes,
we're talking about.
Unfortunately, you can't compartmentalize the diplomatic notes into articles, but the sense that is captured in there is that yes, the personnel of the U.S. Armed Forces would have diplomatic immunity, tax waivers, free movement of their...
all of these are in the 1998 one?
Yes, yes. But the most fundamental ones, the most fundamental ones, which actually touch on our sovereignty, namely the granting the United States Armed Forces unimpeded access to some facilities, you know, within our sovereign territory, of course, which would pass for military bases, is what was not captured in the 98 agreement. So those who actually struck the deal in 98 were mindful that Ghanaians are very jealous of their sovereign status and will not under any circumstance sell out our sovereignty for a measure of pottage. That's the point to make. So there are fundamental differences, and that negates the argument that has so far been made by the Minister for the Defense and even, if you like, the Ambassador of the United States, that this is only, the new agreement seeks to consolidate previous agreements. A consolidation does not add or subtract from previously existing agreements. That is my sense of what a consolidated agreement.
To put it together.
Yes. Yeah, you just put them together. You don't add or subtract. But this is an enhanced cooperation agreement, as captured in Article 2.
The ambassador says merely having 200 security officials from the U.S. in Ghana who can even fit into the embassy's premises is really no big deal, especially mindful of the positives that's likely to come with it. What's your response to that?
And so, even if our sovereignty is at stake, they have unimpeded access. The question is, why? If we're talking about cooperation, why is what is so special about the training, if that is the real intention and motive, that you'd want to have unimpeded access and exclusive use of certain facilities? Why is it so? In any case, the existing arrangements we have had, they should tell us what have been the pitfalls. Have there been any pitfalls such that they are now calling for an enhancement of the arrangements that are already in place if there are no motives that you and I don't know about?
So when they said that they are actually going to do 3 major trainings this year and for the next couple of years in Ghana, And all of this require this particular form of agreement. Exactly what's your disagreement with that? You've been in the Interior Ministry before. You see, you know how security arrangements are handled.
Training exercises with our U.S. counterparts at our jungle warfare school and elsewhere. I mean, the relationship has been very fruitful. Yeah. But I'm saying that we did that within the context of Ghanaian statehood and sovereignty.
I get you.
We did not at any point in time sacrifice our sovereignty, on the altar of some 20 million US dollars that would come our way. We did not at any point in time subjugate our laws to United States laws, even within our territory in relating to personnel of the U.S. armed forces. We have not at any point in time, said that the United States government can bring in equipment without our inspection. At any given time, we should know what is it that they are bringing into our country. It is only fair. And so if you have provisions in an agreement to that effect.
Honorable, let me actually go to the phone lines now. Let me get to speak to the Director of Academic Affairs at the Ghana Armed Forces Commanders Staff College, Dr. Vladimir Chidansu, on this particular issue. And we'll come back to you to tell us what's been happening at the committee level and the way forward on this particular matter. Doc, you're welcome to our front.
Thank you very much, and good evening to your hostess.
The latest development on this front is that the U.S. ambassador is pretty much surprised. He is disappointed that Ghanaians seem to be having a problem with an agreement he believes will give us 20 million each year and also enhance our security cooperation with the U.S. He believes we should be in a position to open arms and embrace this agreement because it's a very good deal for all of us. From where you sit, does it sound the same for you?
Well, I'm equally surprised also about his interest in telling Ghanaians how to think. It's something we are debating, and I don't think Ghanaians go to America to go and debate anything. We don't have that their security horizon for them and things like that. But it is because of the way we ourselves are handling the situation. That is why we are the nerve to even write such a thing to Ghanaians. I believe we also didn't handle the same problem. We didn't focus the problem. And that's why we beginning to look at it.
Well, I think I'm struggling to get you here, Dr. Chidansu, there, and we'll bring you back on the line if you're able to fix that technical difficulty in a second. But let me come back in the studio here and conclude our conversation. So yesterday, you met the minister. He sought to clarify all the gray areas, that your doubts and all the difficulties you have in there. Were you convinced that he's been able to respond to all the questions that were outstanding?
No. We're not convinced, not the least. And so,
is it because you went in there with a mind that you will never be convinced about what he says?
No, we went in there with an open mind.
Because prior to that, he had accused your people of what they call it, leaking out documents to the media and other people.
But that is unfortunate. How do you accuse members of parliament of the minority caucus of leaking documents that are within the custody of government? Are we in government? So if you want to start an investigation,
it was tabled, it was not laid. Between tabling and preparation for labeling was where the problem is.
So if you table a document and it leaks, do you table them before minority MPs? Do you table them before minority MPs?
Vice Chair of your committee is very convinced that the first time he saw a copy of this document was on social media. It was on the Honorable Sam George's Facebook page that he saw one.
And Sam
so
George
he's
said,
also convinced that
Sam George said you've asked Sam George about the origins of the document on social media, and he said he originated the document on social media. He generated it.
No, what he is saying is that he is convinced this can be true because of the what he saw on social media.
I don't think so. I've spoken to Sam George, and Sam George clearly said somebody also sent it to him.
Okay.
And he
somebody in the minority.
Not somebody in the minority, somebody who is not even an MP sent it to him. And he also put it out there. So how do you turn around and accuse the minority as a group for leaking documents? It's unfortunate.
Okay, so sorry. Which gray areas were ironed out? And when are you presenting your report as a committee?
We met today to look at the report and to convince ourselves that all the issues raised have been captured. We couldn't lay it today because by the time we finished having the leadership meeting to deliberate upon the various issues that arose in the course of our deliberations with the minister, the speaker had risen, for the day. So hopefully tomorrow it would be laid, and I guess the plenary would debate it and a decision taken.
Okay, now let me understand this. Have you, early on, you were worried about whether or not this is going to be a one-sided report or not? Has your views as minority on the panel been captured in this particular report?
As much as possible.
Has been captured?
As much as possible.
So is it representative? Is the document representative of all the views?
There are serious legal issues which were raised, and I guess those issues would probably have to be tested in a court of law.
I don't understand what you're saying.
Yes, we raised issues about compliance with Article 75 on the execution of treaties and international agreements.
What does Article 75 say?
Article 75 talks about the power of the executive to execute treaties and international agreements, conventions, and that after such execution, they must be forwarded to Parliament for ratification. So we're talking about ratification at two levels. The first level is the ratification by the executive arm, which is in the form of execution.
Okay, yeah.
And the second level is ratification by Parliament, which is done through the enactment of a law, which of course would pass through the stages of enacting a law. You know, a bill would be laid, it goes through first reading, second reading, third reading, or by resolution. Parliament passes a resolution, you know, in order to ratify. We're saying that the first level of ratification was not properly done. The minister argued that they wanted us to ratify before they do the execution. We thought that that argument amounts to putting the cart before the donkey. You know, so we raised all these objections. And so, legally speaking, we, as the minority group, think that there was nothing before us to discuss. You cannot put something on nothing. It would collapse. Okay,
so you're saying that there was no agreement in the first place?
Absolutely. So for Parliament to ratify.
So what's the plenary going to discuss tomorrow?
That legal argument. Well, we would raise our arguments, our voices to be heard. We would expect the Speaker to rule. If the Speaker, of course, this is a constitutional matter.
Okay.
And so if the Speaker is of the view that because of the constitutional nature and that there is need for interpretation, he hasn't got the power to interpret the Constitution.
Okay.
I'm sure members would want to take up the challenge.
Is it members on your side?
And Ghanaians. Not only members of the minority, Ghanaians.
But you are the ones raising the legitimate query in this particular case.
Yes. I'm a Ghanaian.
Are you bold enough to project it beyond merely...
We have never demonstrated or showed cowardice. We are all interested in building upon our democratic credentials. I want to believe that
you are not timorosos.
The minority has already served notice.
Yes.
That you heard Honorable Okujetu Ablakwa, the member for Saftong and ranking member for Foreign Affairs. I mean, the hint has been dropped that this is something we feel strongly about, and we expect that justice will be done. Of course, I know the Speaker hasn't got the power to interpret the Constitution. If issues of interpretation are raised, I guess the appropriate forum would be the Supreme Court.
So are you saying that the Speaker should just hold on to every action, let the Supreme Court deal with the matter before any action can be done by Parliament? Is that what you're saying?
Well, that would be the discretion of the Speaker. But so far as we are concerned, we're saying that insofar as the executive did not execute the agreement, but rather brought it to Parliament for Parliament to ratify before execution, is a constitutional violation. That is our position, and we feel very strongly.
And you're not willing to test it in court?
We have demonstrated our readiness and zeal
to do so,
to ensure that the laws of the country, including the Constitution, which is the fundamental
Just that
law.
you're not making a definite statement on this particular one, whether you go to court on the matter. That's what
has
I want
already been said.
By who?
All of us, the minority.
That you go to court?
Yes, it could be me.
Okay.
It could be any member of the minority. In fact, it could be you.
Interesting. I'm not a member of the minority, but let me go to the phone lines and get to speak to Dr. Vladimir Chidanso once again. Doc, you're welcome back. I am given to understand that we have a better line now. I was asking a question about whether or not the disappointment of the U.S. ambassador to Ghana is anything that Ghanaians should consider as legitimate cause for worry.
Well, it's very interesting that he is getting disappointed when Ghanaians know what they want and what they think they should be debating. In the U.S., Ghanaians are not talking about Trump or any of the things that are going on. So I'm very much worried that he's rather putting his nose too much into what we should accept and what we should deny. So it's very unfortunate, and it is probably because of the way we are handling the whole thing ourselves. He's seen the weakness in it and he's poking his nose into it and trying to direct the antenna. And so that is how I think about it.
So what's the weakness in our handling of this particular matter?
Weakness in the sense that we are a money's country. In the first place, the document was dealt a secret document. And it was sent the document to the parliamentary committee. When it is killed there in the bipartisan way, it is killed there. When it's accepted, it's accepted. Unfortunately, he knows that we are playing politics with the whole thing. And that is why he's doing this. He knows that the opposition will have their talk, their say, and the government will have its way. That's not the way to handle such a serious security matter. And I've said it several times on several platforms that we are not handling the thing properly. It's not a partisan thing. This is security of the state. No state treats its security with triviality. And we are treating ours with triviality. The opposition has a certain point, a certain position entrenched. Government officials are talking as if the thing is so good and the Americans are saying it's good and therefore we should take it. And once we handle it this way, then any other person who, mind you, security is about national interest. So the national interest of the U.S. is to build bases all over the world. They have a special program for Africa, which is called Tasker Fund. Have our people been studying what the Americans want to do in Africa? Have they hazarded our own security horizon? Have they known what our security needs are in terms of the nature of global hiccups and global insecurity? They know that we haven't done all these. And instead of our parliament sitting there in the back, so you see, we are not even discussing the problem. We are only saying, no, it's not a good thing. No, it's a good thing. Which is wrong. I don't like the way both sides are handling the thing. This is a security thing. Some of the clauses are outrageous. And we must also learn from history, things that have happened in other places. In Kenya and Tanzania, the Black September Group, what they did, created a condition for thousands of Kenyans and Tanzanians to be killed because American bases just flew and tried to go against the miscreant. And the people died. People died just because America was protecting its interests in Kenya and in Tanzania. Are we learning? So why don't we sit down and in a bipartisan way treat this thing like a serious national war and then come out to say, can we rewrite the clauses or throw the whole thing away? But parties are taking entrenched position. I'm surprised that we trivialize security. I'm surprised.
Doc, well, I guess we have to leave it off here. We appreciate your contribution on this particular show, and thank you so much for joining us. Dr. Vladimir Chidanso actually is the Director of Academic Affairs at the Ghana Armed Forces Command and Staff College. He is also one man respected in the arena of international affairs, very much so. And, of course, a former acting director of the Legon Center for International Affairs and Diplomacy, too. Honorable, the very concern of Dr. Chidanso is that, it's either we are rewriting specific provisions of this particular one, which he calls outrageous, or we are throwing it out completely. He is shocked that there's division over this matter when it looks like a bad deal.
We have all talked about the...
But he says that you, the minority, are equally entrenched on the matter too.
Dr. Vladimir Chidanso would always speak his mind, and I respect him for that. But you see, the important point Dr. Danso has made is that the whole thing was shrouded in secrecy. I mean, we did not open up for a national discourse on the agreement, taking into consideration our own national interest. That is worrying. And all along, we have been trying to make the point that, you see, we need to treat this particular agreement devoid of partisan politics.
I get you.
But because the issues raised are coming from the minority, people have attempted to play a game of equalization. In the past, you went into similar deals without looking at the text of the agreement that is currently before us. That is why I took pains to draw the distinctions between the cross-servicing agreement dated 2015 and the 1998 agreement, which came in the form of the exchange of diplomatic notes, to make my point.
Okay, but my question to you, I mean, that's the question that we were discussing prior to going into the phone line. That question is very simple. Your committee, what is the recommendation? Go for it or go against it?
We are in the minority.
No, I'm talking about the entire committee.
No, you cannot have a composite view. We took a certain position. We raised issues that touched on very sensitive matters contained in the agreement, and I think that we've done that, you know, in the early part of the show.
We have explained all of that.
The majority would always have its way.
Okay. So what is the majority saying?
We have insisted that all the observations we made, all the objections we raised, be captured in the report, so that when the report eventually comes before the plenary for debate, Ghanaians would hear us, they will listen to us. In the final analysis, if the majority decides to use their numbers to railroad this agreement through, I mean, would leave the verdict for Ghanaians to make. But we would do our part.
Is the majority on the committee, your committee, is the majority on the committee insisting that this agreement be passed?
Absolutely.
They are insisting.
Absolutely.
Regardless
even in
of
the face of
all the issues that you've raised.
Fierce criticisms we have labeled, yes.
The vice chair yesterday told me that they were considering the taxes matter. Has it been waived? Has it been, or are they willing to pass it in this form, or they are recommending some changes?
Well, some recommendations were made in view of the fact that the report is not out. It's not fair for me to, you know, go into the details. If it comes out, I mean, signed.
Okay.
I mean, as a committee, we have certain principles and, you know, practices that I would not want to go against. But when it comes out, signed, of course, we'll be able to discuss the content in detail. But yes, I can hint that yes, certain recommendations were made, even from the majority side.
Okay. Does it include the tax reverse?
I don't want to talk about the details. I'll be going against the practices.
I just wanted to know
I'll be
whether
going against the practices.
This matter is.
No, I'll be going against the practices of the committee. At least I can speak to the text of the agreement that is before us. The two agreements that were previously reached between our government and that of the United States, and run general commentary.
I get you.
But for the specific issues, tomorrow, God willing, the report to be out and we shall debate it.
Okay, so what is the impact or effect of this debate when you tell me that the entire agreement before the parliament is even...
That is a legal issue. It's a legal issue, right? Yeah. Parliament, nevertheless, as you know, an institution which exists separately from the courts and the executive, would do its work. We're saying that we would raise the legal issue about the constitutionality or otherwise of the unexecuted agreement, whether or not it passes for parliamentary scrutiny. If the speaker thinks that on the face of the record and the law, there is no need for interpretation, he would apply the Article 75, I mean, fair enough. But of course, if the speaker is minded, he thinks that no issues of interpretation would arise, of course, then somebody would have to go to the Supreme Court and test the law.
The minority did, of course, the NDC did a press conference. The NDC actually also said that because the president was awarded some form of award by the Whitaker Group in the US, that's the more reason why he's being so amenable to such an agreement. How did this argument come about?
Well, the minority press conference, to be very frank with you, we've been locked up in Parliament since morning. And when I stepped out of Parliament, I, immediately started moving towards your studios.
Okay.
In order to have this program, participate in this program. So I haven't really had the space to listen to the press conference that was delivered by our able General Secretary, General Mosquito. So I really don't know what was said. But I am aware that at the party headquarters, a press conference was going to be held this afternoon. Unfortunately for me, I was in the chamber. So I don't really know the issues that came up for discussion. But I'm sure the issues, of course, are not very different from what we are discussing now and the views the minority has so far expressed in relation to this agreement.
Okay, so for example, they say that the agreement makes Ghana a target for terrorists, existing relationship with the US is actually sufficient, and that they are also of the opinion that the withdrawal is non-negotiable.
Yes, that we have taken that position previously. So what my party did this afternoon was simply to reiterate the position the minority caucus of the party has taken all along in Parliament.
Okay.
That this particular agreement be withdrawn forthwith. Absolutely. We have also stated that this agreement, if implemented, would occasion the monumental violation of certain fundamental human rights of our citizens without any forms of mitigation. Because the United States personnel would not be amenable to the jurisdiction of our courts. Numerous examples can be cited. What is happening in South Korea, the Philippines. Only last week there were huge, massive demonstrations in the Philippines against the presence of the U.S. military and the human rights violations.
The U.S. has bases in close to 38 or has agreements with close to 38 countries of this form. You cite 2 examples. That's not conclusive.
Even in Japan, Korea.
That's a third example out of the 38 or so.
In Japan?
I'm saying that you just mentioned a third example.
Mention them, all the countries.
But
and they will tell you,
out of 38,
and they will tell you the bitter experiences that their citizens have been subjected to. In any case, Ghana is unique in several ways.
I get your point.
We would protect our sovereignty come what may.
My last question to you is, what can the minority do beyond having your say in Parliament tomorrow?
Well, we expect that the majority would act in a conscionable manner, live above partisan politics, and see reason with us. Because after the debate, we're going to vote. We expect them to do what is honorable and reject disagreement. So we're going there with an open mind tomorrow, with the expectation that they would act in accord with good conscience.
If they don't?
If they don't, well, of course.
You don't have a plan B?
The good people of this country would bear us out.
Really?
The good people of this country would be our witnesses.
You are convinced that this is a bad deal. The best you can do is just say that, let the people of this republic see that we said something. Is that all?
We have hinted that if the challenge we shall mount tomorrow fails, we would seek redress in the law courts. Because we even have issues with allowing a foreign country to operate military bases within our sovereign territory. You know, under the Constitution, only the government of Ghana can raise and maintain an armed force. Okay. So there are various steps that could be taken, apart from the fact that we are convinced that there is no agreement before the Parliament for ratification.
Interesting.
There are other dimensions. So when we get to that stage, we shall advise ourselves. But we don't want to preempt anything. We would go in there with a clear mind and hoping that the majority would reason with us so that together we reject.
You are not even open to amending sections of the agreement before you are just going out for outright rejection?
Yes, we think this agreement in its entirety.
Every part?
Yes, it's not in our
When it looks like an agreement in ties parts, just slight changes?
No, I've told you before that there are fundamental differences. If
those fundamental differences...
If they allow the status quo to prevail, we wouldn't even need this. Because under the current regime, there is some form of cooperation that is already going on.
Which is based on which agreement? Is it based on 98 or the 2015 agreement?
98.
Which is still in operation
today? The 2015 agreement has expired.
The 98 agreement is still in operation today?
Yes. If you read through, let me take you through.
I get your point. Yes.
If you read Article 19.
It says that it supersedes that particular agreement.
Absolutely. So that presupposes that that agreement is still in force, and that is what we're operating under. So let the status quo remain unchanged.
Honorable, thank you so much. My guest today is a member of parliament. He's also the minority spokesperson, ranking member, to be sure, on the Defense and Interior Committee. Until recently, he was a former Deputy Interior Minister. The Honorable James Agaga was with us on Upfront today. Thank you so much for joining us on today's edition of Upfront. My name is Raymond Dalkwa.